Okay, I'm excited to start this panel on comparative corporate governance. I see a few of my students in the room, so welcome to this exciting panel. Just as a way introduction, this panel is based on a book that was edited by two of the panelists here, Comparative Corporate Governance, and the presenters are going to basically present chapters from the book that kind of will give you a good sense of various topics. We're going to go in order. I'm going to introduce the speakers as they come because we're still missing one speaker. So we're going to start with Professor Afra Ripour from UC Davis. Then she'll be followed by Professor Martin Gelter from Fordham Law School, then Professor Vijay Harpur from that is moving to Hong Kong University very soon. And then finally with Professor Vikana from Michigan, who's going to join us in a few minutes, hopefully. So I'm going to moderate any questions that you guys may have. Please feel free to raise your hand with any questions, and I'll take a cue if needed. And I'll let Afra to start.
All right, thank you, Yadon. I'm going to share my screen, and I want to thank you and also thank your colleagues at University of Wisconsin for all the work you've done to organize a conference that you guys originally planned on organizing in person and did all that work and now are doing remotely. So I really appreciate it. So this is one of the chapters of this book, Comparative Corporate Governance. I was lucky enough to co-edit with the fabulous Martin Gelter, who's also here today. And Martin and I have, I will just touch upon it really briefly, of a pretty lengthy introductory chapter in the book where we really go through the various themes that are covered by the other 23 chapters that are in the book. But one of the themes that it's covered is really the issue of corporate governance convergence. And so over the last 2 decades, as Martin and I talk about, there's been a long, detailed academic inquiry regarding whether globalization and increasing financial integration were leading to convergence of corporate governance systems across countries. And so my chapter in some ways contributes to this debate by assessing how corporate governance concerns are reflected in the approach to regulating friendly takeover transactions in the US and UK. And I focus on friendly deals, essentially deals, acquisitions by third-party bidders that are negotiated and supported by the management of the target company. And I look at takeovers specifically because I study and write about M&A and takeovers generally, but also because they're some of the most significant activity affecting corporations and their shareholders. And in some ways, perhaps maybe more than other transactions, they really highlight the tension between the board and shareholder control in publicly traded companies. I think that's true for both hostile and friendly transactions, but I want to focus on friendly deals for purposes of today because there's been so much great scholarship actually written on a comparative assessment of hostile takeovers between the US and UK. And I focus on the US and UK because they're two of the leading jurisdictions for M&A activity, but also they're countries with relatively similar capital markets and relatively similar institutional frameworks. And the takeaway here from the longer chapter is that, despite scholarly pronouncements that convergence to some kind of efficient shareholder primacy model was going to emerge, even the US and UK continue to differ pretty significantly in how they approach the primacy of shareholders and how much power is given to directors in these types of fundamental transactions. And in balancing power between shareholders and directors and takeovers, they've long diverged with respect to hostile takeovers, and there's been great scholarship, as I said, on that. But I also argue that with respect to the rules that govern friendly transactions, they continue to diverge and perhaps diverge even more strongly over the past decade in really meaningful ways. And that in essence, the design of the corporate governance rules and frameworks governing friendly M&A deals, we see this sort of strong pull of path dependence between the two jurisdictions. So I won't talk in much detail about how important M&A is, but M&A is really important. And I always want to get this across in the sense that it's important from a from the way that it impacts economic activity. It's important with respect to how it impacts shareholders. Generally, it's important with respect to how it impacts stakeholders. It's a huge part of the transactional deal-making market. And so I just have a couple of headlines from recent reports that have come out that it also impacts, for those of you who are lawyers and who are law students in the room, it's also really important because there are just a lot of jobs in it, right? So there's a lot that you need to understand about sort of how corporate governance is reflected in M&A, because M&A is such an important part of economic activity. So our book focuses specifically on corporate governance and sort of corporate governance issues kind of generally. And corporate governance sort of goes to the heart of a lot of discussions in M&A and takeovers. So M&A deals raise significant corporate governance questions about the allocation of decision-making power among firm participants, whether and to what extent the participants are constrained in the exercise of their decision-making power, and whether and to what extent they can be held accountable for these decisions. Some of that is reflected also in the deal making and documentation of M&A deals. So public company M&A deals involve complex steps and contracts. They're transactions that unfold over time. And sort of the timing is something that I talk about specifically in the paper. The typical M&A deals involves a variety of decisions from managers of each of the companies. And the ultimate decisions made by the board can be sometimes subject to shareholder voting or acceptance. And most jurisdictions' rules sort of reflect these various complexities in M&A deal making. The other thing I think the rules reflect in many ways is they reflect the ownership structure that's prevalent in a particular jurisdiction. And some of the chapters in our book actually talk about the differences in ownership structure kind of more generally, but they also reflect the political power of interest groups that influence the law. And so if you look at sort of the general legal infrastructure that surrounds M&A, the result is in some ways a mishmash of rules that attempt to balance both concerns about ownership structure and then the desires of various powerful interest groups. With respect to jurisdictions with relatively dispersed shareholders structures, the corporate governance concerns in M&A kind of are, I put them in sort of for simplicity's sake, into like two buckets. Right? And these two buckets in some ways address the principal management, shareholder agency conflict that arise in the pre-signing period and in the pre-closing type of periods. So takeover transactions in the pre-signing period are kind of the quintessential example of deals where managers may face few market constraints and are more likely to face their own interests. In some ways, acquisitions kind of highlight very concretely the conflicts of interest between managers and shareholders in large public corporations. So target managers, for example, might be incentivized to behave opportunistically when faced with a potential acquisition of the company. And I have a little excerpt in the slide from an opinion from the El Paso case, where the court says, the sale of a corporation has enormous implications for the managers and its advisors, and a range of human emotions, including but by no means limited to greed, can inspire fiduciaries and their advisors to be less than faithful. M&A is sort of the perfect opportunity to get the money and get out, right? For a lot of managers on the targets. Bidder managers also face their own incentives, and I've written about this in some of my other scholarship, but bidder management can benefit significantly from a transaction at the expense of shareholders, whether it's through increased power or prestige or compensation. CEOs in particular are financially rewarded for acquisitions, but perhaps are not similarly rewarded for other types of major capital expenditures. In addition, CEOs tend to personally benefit from making acquisitions. Even when these acquisitions have poor outcomes for shareholders, there's a lot of incentive to gain greater prestige and leave a legacy and so forth that we've seen with respect to a lot of M&A transactions. In the pre-closing sort of period of time as well, M&A deals bring up a lot of corporate governance concerns. So because of shareholder voting and other regulatory requirements, M&A acquisitions involve kind of a significant, especially with public company deals, involve a significant lag of time between the time the board actually approves a definitive agreement and when the transaction actually closes. And so there's a lot of risk management that the board needs to do in this pre-closing period. And so one of the things that the parties do, and at most M&A deals, is kind of design a fairly complex contract that addresses a package of rights and obligations with respect to the closing of the transaction. That package of rights and obligations also then potentially involves a lot of incentives to close the deal that management wants to close and that has signed on to. And so the acquisition agreement might include a host of deal protection provisions that might be, termination fees, matching rights, voting rights, lockup agreements, and so forth, that are aimed at deterring third-party bids from emerging in the post-signing pre-closing period. And those provisions might actually be very valuable for getting a deal done. And there are a number of studies that sort of look at the value of those provisions, but they can also raise fairly significant corporate governance concerns. So if you think about target boards, for example, they might use deal protection provisions to deter other bidders to protect their favored bid because they're getting something out of that bid, or to reduce the prospects for negative shareholder votes. So in the paper, and I won't go into it in a lot of detail today because I've got a limited amount of time, but in the paper, I kind of go through the specifics of the rules of how you do friendly takeover transactions in both the UK and in the United States. And let me give you just a general overview of the UK. So kind of two typical types of ways of doing friendly deals, schemes of arrangement, and then the takeover offer types of transactions. And I have sort of a general timeline of both of these types of transactions. And you can see that there's sort of this lag of period of time between signing and closing of the transaction, as well as a lot of sort of pre-signing negotiation time. And my general takeaway of sort of the way I characterize in the chapter the UK is that it's characterized by ex-ante rules that basically try to constrain managerial power and favor shareholder voice. And that is true whether the deals are done via a takeover or some other type of structure like a scheme of arrangement. And it's in line with shareholder rights in the UK more generally, because it's generally accorded shareholders a broader package of rights than shareholders in Delaware corporations have had. So for M&A, if you look at shareholder voting, whether you do a scheme of arrangement or whether you have an offer bid, one of the things that you see is that there's significant voice for target company shareholders, and in some ways a big departure from the US model and acquisitions of significant size. Shareholders of the bidders also have voting rights that kind of constrain the bidder board. And then there's a significant kind of limitation on director power. So the takeover code limits the ability of directors to diminish or frustrate shareholder power through takeover defenses. Target directors can't take any action that might interfere with the conduct of an actual or an anticipated takeover bid. And then one of the things that the UK changed in 2011 is it revised its takeover rules to also really dramatically constrain the power of directors to negotiate deal protection mechanisms. And so it's sort of a key principle in the UK's approach to friendly takeovers is this concept of constraining director power and negotiating leverage. So typical deal protection mechanisms that I mentioned a few minutes ago that are often used in the US, like termination fees or matching rights, can't be used in UK transactions. The US is really different in the way that it balances corporate governance concerns and friendly takeovers. There also is a similar kind of lag of period of time between signing and closing. But the US has historically emphasized the interplay between ex-ante protections, whether that's disclosure or shareholder voice, and then ex-post policing through litigation, often in ways that reflect a director-centric type of approach. If you think shareholder voice, for example, in the US, it's much more constrained than it is in the UK. So not only is the voting threshold lower for shareholder voting in M&A deals, but bidder shareholders are often deprived of voting rights, even in fairly significant sized transactions. While shareholders might have a voice, the transaction sort of structure, and especially in friendly deals, is controlled by management. Management controls the timing and negotiation of the deals. They control the information upon which shareholders rely in deciding whether to approve the deal. Most importantly, they control the entire structure of the deal. So if you think about deal protection provisions in the US, management have wide latitude to use deal protection provisions. And there are studies that have shown that deal protection mechanisms in the US have become even stronger, with kind of a proliferation and expansion in the variety of deal protection mechanisms that provide management with tools to protect its preferred kind of transaction. The one constraint on management control, in some ways, a recognition of the conflicting incentives that are there in negotiating takeovers, has always been litigation in the United States. And so Delaware law has historically provided target shareholders kind of two avenues to hold directors accountable through the courts, and that has been fiduciary duty litigation or appraisal rights. And so one of the things that I go into a lot more detail on in the paper is kind of an erosion of those sets of rights under the Delaware rules. So over the past decade, both fiduciary duty litigation has been constrained, and you see the same thing with respect to appraisal rights, where the courts are really favoring whatever is the deal price that was negotiated by management sort of specifically, rather than going through sort of a long flurry of sort of appraisal litigation. What the Delaware jurisprudence seems to recognize is and emphasizes the value of kind of these ex ante methods that I talk about in the paper, like deal process or deal requirements like shareholder voting, to address corporate governance concerns. And some people say that this sort of shift in Delaware is an elevation of governance and procedure over sort of costly, uncertain, problematic litigation. And some have even said that the moves in Delaware with respect to limiting fiduciary duty litigation and appraisal rights kind of moves the US increasingly towards shareholder power and brings the US closer to the UK model, where the primary role of the target board, for example, is to ensure a stockholder vote. So I think of it actually in some ways like as the opposite of that, right? I argue that once we take into account the authority that the board has in designing a deal and in putting into place a wide variety of deal protection mechanisms, that the move toward expanding the value of sort of ex ante shareholder voice and devaluing ex post litigation in reality actually maintains and reinforces management power in Delaware. And that's like not surprising, right? In the sense that the Delaware approach to takeovers with courts as arbiters of corporate governance disputes has long been concerned with maintaining the centrality of board decision-making. And one of the things I talk about in the paper is that when that centrality came under attack with the rise in fiduciary duty and appraisal litigation, the courts responded to the significant management backlash to these rising trends by reverting to the pro-manager approach of Delaware jurisprudence. And so the US regime in many ways has become in some ways even more director-centric than it was when it comes to takeover transactions. I'll finish up here because I'm mindful of time and I know we have exactly just 20 minutes. But one of the things I think this brings up, and I don't necessarily opine upon it in the paper, is sort of which system is better for corporations, which system is better for M&A decision-making, and which system is better for shareholders. I think there's a lot that needs to be done to sort of explore those types of questions. So I will finish up and I will turn it over to Martin.
So before we get to Martin, I guess if anybody in the crowd has any questions.
Stop share.
I had one comment maybe before we, so one thing I remember when kind of comparing the UK to the US that is always kind of has been highlighted is the slight difference in the shareholding base, where in the UK, although it's widely held, it's much more kind of like blocks of like large shareholders who are a little bit more active to begin with, and kind of traditionally the US has been always kind of portrayed as kind of like the widely held passive shareholders. But the last few years are kind of like showing this change in kind of like both kind of like the size of holdings and the passivity of shareholders is kind of changing. I'm just curious if you think that will also kind of portray maybe a movement towards more of a UK standards and kind of like the long-term future.
Yeah, it's a great question because UK institutional investors have had such a powerful role in sort of designing like the takeover code rules, right, in the UK, and even amendments to the takeover code, like the 2011 amendments that constrained manager ability to negotiate deal protection provisions, something that was driven in many ways by the big institutional investors in the UK. I don't know if I see that in the US. I mean, generally, you haven't seen at least the shift in institutional investors sort of translate necessarily into differences when it comes to sort of the M&A rules in the US. And certainly as you started to see a shift in the US of greater concentration of shares in the hands of institutional investors, you saw in some ways, and then some activist investors as well with respect to the appraisal rights and so forth, what you saw was this sort of response by the Delaware courts is like, we're pulling back again, right? For a little bit, they sort of opened things up for things like appraisal rights, and then they pulled back pretty significantly. I think we have sort of a model that's still where, I don't know, director power seems very embedded, at least when it comes to these types of decisions. But I mean, could potentially have, it could potentially change down the line, but I think we're kind of far from where the institutional investors in the UK are in being able to impact sort of corporate governance rules and M&A.
Yeah, although with this like even recent kind of BlackRock announcement that they're gonna basically listen to other investors when they make voting decisions. I don't know. You can see long term. I could see the US, at least the shareholding composition, becoming more and more similar to the UK in a way that then we'll be kind of like asking questions that are more kind of apples to apples, because when you compare the US to the UK, there's always kind of like, but in the UK you have like the strong institutional investors, you have the city code, you have maybe kind of like soft standards that are not developed in the US. It will be just, to me, it will be interesting to see if we move there as far as kind of like the background, whether that will actually change Delaware's view or even federal regulators' view.
And whether even like shareholders will literally exercise their voice in a different way, right? Because so far they haven't exercised their voice in friendly deals in ways that really constrain managers. Or do they push, on buy side deals? Like, will they actually push for voting rights in a different way? Certainly, if most large buy side deals, the shareholders don't have a voice at all, right? So
the only interesting thing will be with the common ownership pressure they're facing. They might be reluctant from doing that. So it's all kind of like interconnected on various levels.
It is.
You can watch, I'll pass the talk to Martin here.
Yeah. I mean, I was just wondering, in addition to about Afra's paper and Yaron's question, whether we're also seeing some change in the composition of share ownership in the UK. Right, I don't know enough about it, but there's been some discussion about, there are a lot of companies from abroad that are not dispersely on the list there, right? And on the other hand, probably you have more foreign institutional investors in the UK, so there could be a change on that side. So all countries are looking more and more similar, I think. But I don't know.
And I think some of the changes in the UK rules are sort of the UK takeover rules are sort of in response to worries about those shifts in ownership.
Yeah. Okay. So should I start with my presentation then? So it's 20 minutes.
Yeah, you can.
Okay.
Yeah.
Okay. So first, let me thank you for the Society for having me here, and for Yaron for hosting this, and also Afra for being such a great co-editor in this book. I mean, I think we started this project because we were sort of interested in different things, actually, and within comparative corporate governance. But we were always so much on the same page in terms of how to sort of put together the list of authors, how to select topics, how to run the conference that we had for the participants, how to review chapters. So it was just such a privilege to be working with you, especially since you had a lot of other things to do as associate dean at some point. So it's been really a wonderful full experience. So I really enjoyed that, and I feel like I learned a lot from you. And from the authors, and I'm really grateful for some of our authors being here. So let me start talking about the chapter, which is on accounting and convergence. So it tries to bring together two topics: convergence in corporate governance and international accounting, which is a bit of an out-of-the-box topic, I suppose, because most corporate law scholars don't know that much about accounting debates. And one might think that the topic is kind of trivial because, on the one hand, you could say there's been convergence toward Anglo-American standards. So in sort of a greater influence of international financial reporting standards around the world, but not so much in the US in the sense that there's been this split in that the United States companies still use US GAAP and they haven't adopted IFRS, so International Financial Reporting Standards, like much of the rest of the world. So you might say, on the one hand, there's been a lot of convergence everywhere, but the US being the outlier, right? But so what I want to say is this is not entirely true. This is sort of maybe a stereotype, maybe a limited view of how things are. And I do want to emphasize the in this context, I want to emphasize the role of why convergence does not work, what path dependence prevents convergence. And the argument in this context is that for convergence and non-convergence in accounting, there is a key interest group that determines it, and that is the Big Four, or used to be Big Five, used to be Big 20 in 1980, accounting firms. Their interests determine whether accounting standards converge across countries or not, to a large extent. So, so I think most of us are probably going to be familiar with the convergence debate in corporate law and governance, which Afra introduced also in her presentation, sort of the trend toward shareholder wealth maximization, the trend toward emphasizing the interests of all shareholders. So not just the controlling shareholder, but we want to protect investors around the world, which was, a dominant trend to the 1990s and 2000s. Most of us will remember Hansman and Crackman's famous proclamation of an end of history for corporate law. And this, there's a lot of debate to what extent that actually happened. My sense is it kind of stopped a bit or has taken a different direction in the last 10 years or so, now that we're discussing sort of maybe a stakeholder-oriented model of corporate governance more than we used to. But still, I think it is a worthy issue to study why it is happening, why it is not happening. And I think the main argument back in the day was that shareholder model is the most efficient model, and which is why in increasingly open markets with competition between firms in product markets and capital markets, we're going to see the convergence to the model that is most efficient, which is maybe the shareholder model, at least according to its proponents. Now, there have always been arguments why convergence will not happen, right? So corporate governance systems might adapt only formally, superficially. So you might have only formal convergence without functional convergence. You might have a legal transplant effect that does not work as well as it should. So transplants do not always translate one-to-one into a different legal or socioeconomic environment. And one specific rule might have a very different impact in another jurisdiction. So what I try to emphasize in this chapter is the role of path dependence, and sort of given the types of path dependence of the discussions that we see in the literature, I sort of try to classify it into two categories. One that one could call political, where you have specific interest groups that determine, that have to benefit from a particular existing rule. So for instance, controlling shareholders might object to rules that favor outside investors. And on the other hand, one could speak of what some scholars have called doctrinal path dependence, and which is supposed to be rooted in the internal structure of the legal system. So doctrinal pathways that solidify over decades or centuries frequently depend on the happenstance of a particular legislative or court decision that was reasonable at the time, but maybe suboptimal today. Legal doctrine, therefore, self-perpetuates, and legal systems which have a limited set of doctrinal tools available apply the available tools as the new law, new challenges appear for the law. Now, the chapter suggests that the two types of path dependence are linked because doctrinal path dependence can, at least to a certain extent, be interpreted as a protection of human capital, of sunk human capital investment of legal professionals, or in the example studied in the chapter of accounting professionals who want to continue to basically draw certain benefits or rents or quasi rents from a legal system in which they operate. Now, so where's accounting in the legal system? Where's accounting in all this? So in the US, I think we often think of international financial reporting standards as foreign standards that are trying to colonize the United States. They come from, from Europe or from the UK. Where they were first adopted, the EU endorses them. So it's not a big surprise that there is a resistance against them and why the SEC still does not allow to use them. From the European perspective, this is not entirely true. Europe has, since the 70s, had a level of harmonization of accounting through EU directives. And it has generally had a more legal approach to accounting. So in countries like Germany or France, we would use terms such as Bilanzrecht or droit comptable to emphasize that accounting standards are actually some type of legal rules that may in some jurisdictions be part, for instance, of the commercial code, or as in France, it was historically developed by a commission put together by the government with the input of various interest groups. So accounting standards was much more legal, and this had a lot to do with different purposes of them. So in the United States, when we think about GAAP, they're developed by FASB for publicly traded firms for the benefit of investors, which is not necessarily the only objective that traditional accounting standards and systems had in European countries, or I understand also in Japan, for example, where the situation is similar. So US GAAP were historically investor-oriented, and the same is actually true for international financial reporting standards, which say they're for every user of financial statements, but in reality, they come very much out of an investor-oriented environment. Whereas traditional continental European accounting standards were often linked to, for instance, the proper computation of corporate profits for purposes of the legal capital system, for the computation of corporate tax with a greater role of book tax conformity. Which one thing I think I haven't said, basically the same accounting standards would apply to all limited liability business associations in European countries compared to IFRS, US GAAP, which are really just intended for publicly traded firms, or primarily intended for publicly traded firms. So one could wonder whether differences that we see are linked to different varieties of capitalism, to a greater investor orientation or creditor orientation in corporate governance. So that's all ideas that people have thrown out there over the years. And then there is the difference in the standard setting process. So for instance, in the United States or in the UK, in the context of IFRS, it is clear that accounting standards are and were developed by a professional body that has been historically dominated by the big accounting firms, by investors, by accountants from big publicly traded companies, which is not true, as we said before, in necessarily in all countries. So think about the German sort of historical idea, at least, of development of principles of proper bookkeeping in a deductive process, very much like the interpretation of law. So there are certain differences, have been certain differences, and those of us who I think know a bit more about continental European accounting will see that the adoption of international financial reporting standards was actually a much bigger leap for these countries than their adoption would be for the United States, where basically IFRS and US GAAP clearly have the same purpose, which is to provide useful information for investors primarily. Now, so how has convergence happened or not happened? So of course, the EU directives that try to harmonize accounting principles across European countries have been called a weak force of convergence by Henry Hansman in the corporate law context. One would argue that EU harmonization actually was some kind of counter-convergence to a different variety of capitalism. But as a matter of fact, the International Accounting Standards Committee, which is the predecessor of the current International Accounting Standards Board, was created in 1973 as a reaction to the beginning harmonization in Europe, because the UK and Ireland had joined the EU, and accountants there were concerned that they would be overwhelmed by these continental Europeans and their ideas, which are very different. So they got together initially with professionals from other common law countries, from other English-speaking countries, to develop an alternative approach. In the 90s, in our core convergence period, the continental Europeans had lost faith in their own accounting standards for purposes of publicly traded firms. They had lost faith in the sort of EU harmonization in this area, because it clearly accounting standards across countries still were not comparable. And there was this push for firms to tap capital markets more strongly, which led to a stronger push toward adopting international accounting standards and US GAAP. So a number of countries allowed that for publicly traded firms for consolidated accounts for the first time in the late 1990s. Now, how did convergence happen in this context then? How did convergence operate? So the chapter argues that in Europe, we're really only seeing incomplete convergence to IFRS. It is true that the EU has, in a directive of 2002, adopted IFRS, so there is an endorsement process for integrating them into the EU legal system. But traditional continental European accounting very much survives in non-publicly traded firms and in a number of countries also for purposes of measuring dividend distribution and taxation, corporate tax basically, in large firms, in publicly traded firms, and companies in Germany, for example, they have to do both if they are publicly traded. The argument that the chapter is trying to make here is that this compromise that we saw emerge in the EU and in the individual continental European countries is very much an interest group story. We see, I think, the interests of the local branches of the big five accounting firms in gaining a greater market share in the respective countries in order to basically by promoting international financial reporting standards, which more localized firms had a hard time to adopt to. So, of course, there was local resistance by other interest groups, smaller accounting firms, maybe also legal professionals who had some vested interest in corporate law and tax law. So we see, I think, a compromise that emerged between sort of the international push and the local, the local static approach, if you will. Very different situation in the United States, where, as many of you will know, there was a big debate about adopting international financial reporting standards after Enron and the Sarbanes-Oxley Act. The SEC was considering ditching American GAAP entirely and introducing international financial reporting standards. Eventually they did not do it. The chapter argues that this has much to do with the rules versus principles debate. So the idea that GAAP are more specific than IFRS, which rest more strongly on broad principles, as they are mostly inspired by models in the United Kingdom, where IFRS, the IASB is based. And that there was this perception that basically a principles-based system would invite a greater degree of litigation in the United States, right? Something we also discussed in the previous presentation, that in the United States, litigation by investors is a very strong aspect of how corporate governance works. Whereas in the UK, this has not been such a case, which is why a principles-based system may have been of greater use there. So the argument here is that a different compromise likely emerged in the United States because a full introduction of IFRS in the United States would have harmed the interests of the accounting profession domestically, and possibly also the interests of publicly traded firms who might have subjected themselves to a greater risk of 10b-5 litigation, for example. So that so we can see, if we look at Europe and the United States, we do see, if we look more closely, that the story about accounting convergence and non-convergence, convergence and persistence is not so simple, right? When we look at Europe, the argument is that it served the interest of the large accounting firms to increase their market share by promoting an internationalization of accounting relative to local accounting firms and local and other professionals. Whereas in the United States, the non-adoption of IFRS is consistent with the interests of accounting firms, especially in the context of the level of investor litigation. So a different compromise emerges depending on different structures in the legal system, which you could call, which is certainly an aspect of path dependence. Maybe it is doctrinal path dependence, but it's certainly also interest group driven. So thank you.
Thanks, Martin. As you were talking about it, it's partly kind of informed by recent EU steps in corporate law. But one thing to kind of think about is kind of like top-down or down-up type of adoption. And it seems like, especially more recently, but I think generally speaking, some countries in the EU are just quicker to act on policy matters in a way that can dictate kind of like either convergence or, the other way around. You can actually make a case that the EU is starting actually to move away from the US model on many items. And that's kind of like being driven by, legislator and not probably like the interest groups and the US is traditionally has been dysfunctional politically. So most of the changes are done kind of like on the ground, interest groups, policymakers, judiciary, all of that kind of like playing kind of like in a ring. So I was just curious your thoughts about that, and not necessarily specifically in the audit context, but just more general.
I mean, I think that the EU legislation, on some level, it looks at least as complex as legislation on the US level, right? If you're comparing it to the federal level, right? Because, you need the, others know this better than I do, but you often need a majority certain majorities among the member states and in the EU Parliament, which is a very complex institutions with representatives from all countries and different parties, and which is very unpredictable because, there's the country interest and then there is the party interest, or and it is very, which are very, very diverse, I think. So I think in the company law harmonization or business law area, to the extent that it is EU driven, I would think that there is a certain technocratic impetus usually coming from the Commission, which convenes specialists often, sent by the member states to prepare drafts. But then, unpredictable things can happen in the Parliament. But it depends a lot, of course, on what happens in the member states in the first place. And when we think about the accounting examples around the year 2000, I think at least in many countries, there was a strong push in the Hanselman and Krachmanian sense toward, we need to cater to investors, we need to cater to capital markets, we need IFRS, we need US GAAP for our firms, right? And that sort of eventually translated to the EU level. But I think some of it comes from the technocratic level, and it's still true if we think about, for instance, related party transactions. So the 2017 amendments to the shareholder rights directives, right? I think there isn't really a clear interest group that drove this, but there is a sense. I think this was in part driven by debates in the member states about what company law should be like. Even debates among scholars, I think, had a role, because sort of the idea of we need to regulate self-dealing transactions or related party transaction more strongly was getting very important. But still, within that we can see a lot of compromises where member state interest groups, large controlling shareholders, prevented meaningful regulation. And for instance, you've got these minimum thresholds when you have to report and vote on related party transactions in the shareholder rights directives, where there are member state options. And I think the member state can set a percentage of, for instance, total assets of the company, below which you don't have to report it publicly and you don't have to have a shareholder vote. And then some member states have set them really high, like 5% or 10%. And then, the sort of the technocratic wish to make corporate law better, or the expert wish to make corporate law better, is undermined by, I think, probably exceptions that are driven by interest groups, right? So.
Desmond, I see, Regina, you have a question?
Yeah, I'm just curious, Martin, to hear your thoughts on the extent to which your observations about accounting convergence and path dependence might carry over to the implementation or reception, whether in Europe or more broadly, thinking obviously primarily from the US perspective too, of some of the new initiatives in the EU around sustainability disclosure, and in particular the upcoming efforts of the International Sustainability Standards Board that I think are intended to mirror the efforts of the IASB. And my understanding from the 2014 non-financial reporting directive is that there was very diverse experience in the EU in terms of implementation that really was consistent with the path dependent story. But I'm curious to hear what you might say about, or might expect to emerge from these, kind of leading efforts in Europe to introduce new sustainability transparency, given what you've seen in the accounting space. And I personally expect that those might parallel, but I'm curious to hear what you think.
Yeah, I mean, I don't really have a very strong view or strong opinion on where these things are going. My sense is generally that I think we will probably see something like you described, very divergent experiences, because EU harmonization typically has the so it's usually allows a lot of member state options. So like my example from the Shareholder Rights Directive about related party transaction thresholds, and that really allows the member states to make sure things that are really unpleasant, will not be, will not be implemented in that way. I mean, I think the accounting space itself is maybe to some extent exceptional because you do have this very you have this standard setter, right? IFRS, which whose standards are then endorsed by an EU body, and I think there has been one case where sort of non-endorsement actually forced them to go back to the drawing boards and make changes. But in most cases it will just be accepted. So so to the extent that these standards are taken out of the regular EU process and into a separate standard setting process, I think we might actually see something more more closely harmonized. I mean, in the core accounting area, of course, the thing is, the issue that I've described is where does it apply, right? It does not apply to it only applies to the consolidated accounts of publicly traded firms. So, but I mean, these are the ones that are of interest for ESG reporting, and we'll see. If this will have an international body that's in charge of this, I think then we might see something, and it's taken out of the political process to some extent. Then I think we might see more harmonization there than otherwise.
Okay, thanks, Martin. We are out of time, so we're going to move to Virginia now.
Thanks, Martin. Really appreciate your perspective on that, and it'll be interesting to kind of look at this as it goes forward. So thank you to Afra and Martin for, first of all, putting together an amazing volume that has just been a great resource even already, and also, of course, the University of Wisconsin and to Yaron for moderating today. So my chapter in the book is on corporate board duties with respect to monitoring, risk management, and compliance. And my contribution to the volume was to look at the mechanisms of risk oversight and risk management and compliance through a comparative lens, and drawing examples primarily from the United States, the UK, several European jurisdictions, and China, as well as from international guidance. So I'd like to follow on Martin's presentation by highlighting today a number of observations from the broader survey of different jurisdictions' approaches to board fiduciary duties and risk oversight that I did for purposes of the chapter, and then talk a bit about areas of observed divergence in this space, and then make a couple other points. So first of all, there's broad agreement across jurisdictions that corporate boards have a basic monitoring or risk oversight obligation, and in fact, there's a recognition that risk oversight is one of the most important functions of corporate boards, particularly in the modern time. And in particular, expectations of board monitoring are common across the jurisdictions that I've referenced in the chapter, regardless of whether they adopt a single tier or a dual tier board structure. And as many of you may know, dual tier structures are more prevalent in certain European jurisdictions, whereas the US and Commonwealth jurisdictions, as well as other European jurisdictions, adopt a single tier structure. In addition, board monitoring is emphasized across jurisdictions, regardless of the diversity of the dominant ownership patterns across jurisdictions, which we've also discussed. And I found interesting, that board monitoring is still the expectation, even in markets where you might have highly concentrated ownership that we might think of eliminates a need for monitoring. For example, in jurisdictions where family ownership or even state ownership predominates, nonetheless, these monitoring board structures and rules governing monitoring board structures are quite common. In part, some of the commonality is due to the strong global influence of the U.S. Sarbanes-Oxley Act way back now 20 years ago on corporate governance reform in many jurisdictions, including in Europe, again, dating from the early and mid-2000s, that had prompted many companies to adopt similar internal mechanisms, even if maybe the workings of those mechanisms are different in different jurisdictions. A second observation is that fiduciary duties of care and loyalty are widely used to hold corporate boards accountable for carrying out their oversight function, and that fiduciary principles are really ubiquitous, both in civil and in common law jurisdictions, and then in jurisdictions like China that have drawn fairly liberally on both traditions. Even though fiduciary duties are a concept that really originated in common law jurisdictions. So again, risk monitoring is a consistent theme and expectation. And then how do we get boards to actually do that? Fiduciary duties appears to be still a dominant mechanism and model, at least formally. However, not surprisingly, there is considerable divergence and variation across jurisdictions in the nature and source of this risk oversight responsibility of corporate directors and secondarily officers, in part because of the diverse institutional settings in which board risk monitoring occurs. So just to kind of lay out a couple areas of variation and divergence, one area of difference has to do with whether fiduciary duties extend to both directors and officers, which is the dominant model found in most jurisdictions, or maybe is only responsibility, so fiduciary duties maybe apply only to directors. That's true in Japan. And another source of variation is whether controlling shareholders also owe fiduciary duties. And these are most explicitly laid out in German law as well as in China. While in the UK, France, and Switzerland, there's not the concept of controlling shareholder duties, and the US is kind of an intermediary point there. Another fundamental difference among jurisdictions is the question of whose interests are relevant to risk management and oversight, which aligns with this question of to whom are fiduciary duties owed. And for example, in Germany and France, as well as the UK, define the interests of the corporation itself to include non-shareholder interests in a way that other jurisdictions like the US do not. In the US, even though we've had a lot of movement recently and a lot of conversation about maybe moving to a more stakeholder-oriented model, nonetheless, US fiduciary duty law continues to reflect a strong shareholder orientation. And so this kind of carries over to how these different jurisdictions view risk management and then the risk oversight function of the board. So another observation from the comparative survey is, and this will be no surprise to most of you here, is that the complexity of modern corporations and of the risk environments in which modern corporations operate worldwide is really challenging boards' capacity to monitor and manage risk effectively. And you just have to wait for kind of the next scandal of the day to realize this is a really hard thing to keep ahead of and on top of. And so in the paper, in the chapter, I outline a couple of reasons why, kind of unpacking that complexity and understanding why this is the case and identifying some of the sources of that complexity. And one of the things that boards continually have to grapple with is how to handle emerging risks. So we can think of cybersecurity risks, we can think of climate-related risks, just to name a few. Pandemics, who knew? Another big area of risk management for corporate boards that they didn't anticipate or see on the horizon. In addition, the global business environment is just increasingly complex with diverse regulatory networks, both public and private, that are at once integrated but also fragmented. So again, very challenging in terms of how to manage compliance, how to keep on top of emerging trends, and certainly across jurisdictions. And these are themes that I think this conference is particularly exploring, and I'm sure that there's other panels that get at different aspects of this broader environment in which boards operate. But all of this, consequence of all of that, I think, is a really increased demand for board expertise and specialization in the composition of boards, as well as increased demand for new perspectives to be brought onto corporate boards, whether that's in conversations around board diversity or through demand from investors for board refreshment and concerns about overboarding. So just kind of the general overload of risk oversight is kind of driving a lot of those conversations, I think. So a broader conclusion of the chapter, though, and this is maybe a little bit of a pushback on the assignment I was given originally by Afra and Martin, which is to talk about boards and fiduciary duties. So for better or for worse, one broader conclusion of my chapter is that in a context where risk oversight has just gotten harder, corporate boards' role in monitoring compliance and in overseeing the enterprise risk management functions is now really defined much less by corporate law and by fiduciary duty across jurisdictions than it may have been in the past. So if we're looking to kind of corporate law solutions or corporate law incentives for boards to do this well, my reading is that these mechanisms are less significant, and that may play out, again, differently in different jurisdictions, but it seems to be fairly a consistent trend. Instead, corporations and boards themselves now operate, again, within this transnational network of interrelated actors, regulatory regimes, and other institutions that affect how far the board's duty to monitor extends, how it carries out that function, and how seriously it takes the monitoring role. And therefore, board monitoring as an internal source of accountability and control has to be understood in relation to these varying sources of corporate oversight that really go much beyond the bounds of corporate law and corporate governance. So in the interest of time, I thought I might just highlight some of the key actors and mechanisms that I discuss in the chapter. There's kind of a section that kind of talks a bit about how these different mechanisms offer incentives or speak to the risk oversight role of boards and to the risk management function, and that maybe will help incentivize board risk oversight more effectively than traditional corporate fiduciary duties, which are rather weakly applied in most jurisdictions. So some of these mechanisms include, no surprise, shareholder monitoring. So again, shareholder activism, investor stewardship, which has kind of trickle-down effects on corporations themselves, stakeholder monitoring. So for example, global networks of both local and international NGOs, as well as direct engagement by employee representatives, consumer groups with corporations around areas of risk or potential strategic concerns. Creditor risk monitoring, which is not anything new in corporate governance, but I think is important to mention here, so to the extent that creditors do engage in monitoring certain types of risk that might be undertaken by management. And importantly, companies' own voluntary commitments under various self-governance or private regulatory regimes, which have really just proliferated in recent years. And then finally, there's indirect regulation by governments of the risk oversight function through various soft law and disclosure regimes, which ask corporations to indicate to the extent to which they have monitoring of certain types in place, or whether they're monitoring certain risks. And again, climate-related financial risk is one that's kind of currently up for discussion, but that's just an example of, again, kind of the indirect disclosure-based regulatory approach that is driving corporate boards to focus more on monitoring and measuring and perhaps managing and mitigating certain kinds of risks. So in conclusion, the relevance of fiduciary duties in motivating effective board risk oversight appears to have declined, even in common law jurisdictions, as external risk regulation has expanded, again, whether under capital market regulation, other statutory regimes, soft law, corporate governance codes, international corporate governance standards, whole range of external mechanisms. And I think these observations raise a number of interesting questions for further comparative research about how to encourage corporate accountability as well as effective risk management. And I think that analysis should, again, for reasons I've already discussed, include traditional regulatory and case law studies, but we'll also need to extend more broadly to consider how these other private and market-based oversight incentives affect companies and corporate boards in different jurisdictions. And even today, there's already been a number of panels that get at some of those issues, but it certainly does broaden the lens, I think, for looking at corporate accountability and the risk oversight function of corporate boards. So again, great pleasure to be a part of this volume and also part of this panel. Thank you.
Thanks, Virginia. This is fascinating, and it's close to my heart. I do a lot of work on directors, but I guess one question I have, well, it's more kind of two observations that I would like to hear your input on. But one is that maybe 20 to 30 years ago, the type of risks that board had to kind of monitor for were very idiosyncratic, right? They were very company specific or country specific. And it seems like a lot of the risks that we are talking about today are global, right? So that's kind of quite a distinction that is interesting, kind of, to me, is interesting to think about, in the sense that cybersecurity hits companies across, there's no borders to that. Environmental impacts, all of those things are kind of global in nature. So those are kind of like disruptors maybe of like the country specific systems. And I guess the second thing is, as corporations become more multinational, even if they're incorporated in one country or the other, they are subject to compliance regulations across borders, right? So I'm just curious, how is that kind of like interplay with kind of like the world? Like, you can think about it as a way that forces the board to import mechanisms otherwise they wouldn't have used, just because they need to comply with very specific country specific compliance systems.
Yeah, thanks, Yaron. So I very much agree that there's been a shift in the external environment, and that has increased complexity, but it has also, I think, created an interesting moment where different regulatory regimes globally are looking at very much the same issues. So if we step aside from the corporate side and look at kind of regulatory responses or incentives that might help boards or nudge boards to better attend to certain risks like climate risk, there's kind of a commonality there, and there's an opportunity perhaps for harmonization in a way that wasn't really part of the equation before. At the same time, I think that does lead very much to the second point you made, which is that we're not talking about companies that are operating primarily in the jurisdiction. The United States may be incorporated in a state, but at least in the United States, maybe your operations were domestic in that sense, and therefore largely homogenous. That's certainly not the case now, and it's not only Western home country multinationals. We have emerging market multinationals that are exactly in the same situation, and so we're kind of in an interesting moment there as well, because to what extent do tougher regulations in Europe have to be attended to by boards of U.S. companies with significant operations there? To what extent do regulations in the U.S. and the EU impact Chinese multinationals who are invested in these markets? And so some of the conversations we had 20 or 30 years ago about the inability to reach the multinational, I think they kind of rest differently now. I don't think we've solved that problem by any means, but this kind of network of regulatory constraints from a governance and a government perspective, and then from the corporate standpoint, there's just more to manage. How to navigate. And we're seeing that particularly right now, I think, between, companies being caught between competing expectations between China and the US, or China and the EU, for example. So this presents new risks, regulatory risks in particular, but also compliance risks that, again, companies 20, 30 years ago might not have had to grapple with. So I 100% agree with you on both of those observations, for sure. I think, Afra, you had a question or comment.
I had because two questions, kind of very separate from each other. I like this chapter a lot. I've relied on it already for a law review article I was working on risk management issues in India. So thank you for writing it. One question I had is I was just curious about your response and how you think about the fiduciary duty issue plays a role, given the proliferation of oversight cases in Delaware this past year, because it has, to a certain extent, I thought Caremark had died, and then it's all revived again pretty significantly. And then this question about, and you touched upon it a little bit, this tension and this pressure on boards to increase, expertise and diversity, like really significantly in lots of different ways, right? We're getting beyond just the sex diversity on board, but sort of pressure for racial diversity and other things. And then balancing that with the increasingly complex risk environment with different regulatory regimes that boards have to be attuned to from lots of different jurisdictions. And I just wonder sort of your thoughts about like how to balance all of these competing expectations in an institution like a board that kind of has to remain somewhat small, right? You can't have a 25-person board of a publicly traded company.
Yeah, those are great questions, and I know those are issues that you think a lot about. I think I'll start with the first one because I'm actually was just teaching Caremark literally yesterday in BizWorks, so this is all very fresh in my mind. And the funny thing was, I'd already pulled some kind of summary of Marchand and the cases from last year, and then literally yesterday, I think the Harvard Law School Corporate Governance Forum had another post on it. But I just finished teaching it, so now I had to present present yet another update. Okay, this is why you need to read this case and understand it. And I had very much your same impression, which is that okay, and it's out there. It's kind of an outer bound to kind of motivate us to do minimum level risk oversight, but does it really have bite? And I'm working on another project, which has been really fun with a UK scholar and a scholar who has a kind of German perspective and background, which, like Martin, I very much learned from and enjoyed. But those are jurisdictions where there's maybe a little bit more bite to fiduciary duty, at least formally. And so we were kind of talking about that. And, I see it as nothing. I understand the rationale for the highly deferential kind of very high threshold that you have to cross to even, get past a motion to dismiss. But I'm not sure that it's a bad thing to have Delaware say, there's a space for these cases to go forward. There's a need for, companies and boards to really take monitoring seriously, even though, yes, it's hard. Yes, it's complex. Yes, you may need to get more into the weeds. But the other important point to mention, and I think this was brought out and maybe established more firmly in the Citigroup case a while back, but Delaware has taken the position that the only types of risk oversight that it's going to entertain are legal risks, which is the compliance space, not business risks, which gets into kind of questions involving the business judgment rule and all of that. And so we're not talking about opening the floodgates to some novel new thing. We're talking about you need to follow the law and make sure that you're following it. And it is getting more challenging. No question about it. But I don't know that there's a bad thing in letting some of these cases move forward. And really kind of signaling that this is a real expectation. And I think that's consistent with Caremark. I mean, Caremark said, you've got this kind of standard of care, what we expect you to do. We're just not going to hold you liable for violating that. We're going to set the bar a little bit lower. So, I don't know that signaling is a bad thing. In terms of your second question about what on earth to do, I actually had this question first occur to me a while back when sustainability issues were first beginning to be talked about. And there's this question of where do they fit in terms of corporate board committees? Should it be under the audit committee? Should we have a separate sustainability committee? Does it belong in executive compensation or all of the above? And I think that points to the broader question. And at that time, there were so many other things that were kind of coming onto the plate of the audit committee. And, the folks that are on audit committees are not necessarily well versed in sustainability. Maybe they are now, but I think the sense is that kind of there's been a move towards specialization perhaps. And I think that does raise an important question that you mentioned, which is, how do we get all this expertise? And, maybe kind of more frequent board turnover maybe is one part of that, allowing new voices, new perspectives, new areas of expertise to be added to the board in some kind of greater frequency than we have in the past, maybe a way of getting at that. Maybe as we see this push toward greater diversity, my hope is with the diversity conversation that it's not only about identity and it's not only about speaking for your community, it's about viewpoint and perspectives and experience that you bring that maybe are aligned with those identity vectors, but that what we're really trying to get at is different voices and a willingness and ability to speak up and raise a hand when there's a risk that's on the horizon. And that's where, some of the gender diversity initiatives might have value based on some of the literature. But I don't know that we can do what we might want to do, which is 25 people in the room and they all check a box of their area of expertise. And because this is a comparative conference, I'll just stop talking in 1 second after I say one more thing, which is, as you know, in the US, we're just so US centric. And so one of my concerns with US boards, and it may be that the business community is better in this respect than the legal community or the academic community. I don't know. I hesitate to put my trust too much there. But I worry that we don't have enough understanding on corporate boards of what's going on worldwide. Again, I do feel that folks who are engaged in international business, they rub shoulders with these issues, and it's kind of part of the culture in a way that maybe it's not in academia or it's not in the legal academy, certainly. But my hope is that we can have good cohorts of boards that are looking at what's happening in Europe, what's happening in Asia, getting a sense of other ways to do things, getting a sense of how other jurisdictions are approaching risk. But yeah, no wonderful solutions on that point of how we can do it all at once. Yeah.
Thank you, Virginia. So for our last presenter today, Professor Vikarana from Michigan.
Thank you, Yaron. And let me begin again by thanking our friend Martin for putting together this book. It's fabulous. I have it right behind me on my bookcase there. I apologize in advance for the light over my head. It makes it look like I have a halo, and nothing could be farther from the truth. But there it is. What do you do? All right, I'm going to try to share my screen here, and Yaron will tell me if I completely butcher it. Can you actually see my screen? I don't know. You can see the slides? Okay, excellent. So then I will try, and hopefully this will work. So thank you also to the University of Wisconsin for organizing this conference, and to the Society for inviting us. All right, so my topic is on corporate law and economic development. And from a comparative perspective, of course, for emerging markets, and even for those that are a little bit more emerged, this has always been sort of thought of as the payoff for having better corporate law and better corporate governance, is that it will facilitate capital formation and, as a result, encourage economic development. So what I hope to do in this chapter is to basically explore this relationship with whatever conceptual and empirical evidence we have, and maybe even identify a few questions for further debate and discussion. So as many of you know, the relationship between corporate law and economic development has triggered an absolutely vast literature. What I'm hoping to do, as I mentioned here, is basically trace those debates and the sorts of embedded assumptions that are found within them. The core part of the relationship is basically that corporate law is viewed as a form of investor protection, which may, encourage investors to place their capital within firms that they don't control on a day-to-day basis. One of the big questions that has sort of come up in the literature is the direction of causation. That is, does better corporate law lead to more growth, or is it that better growth leads to more or better corporate law, or something else? Hopefully we'll touch upon that in the talk today. Another question, which I thought would have been more fundamental, is does better corporate law, however defined, contribute to an increase in actual investment? Because the channel through which better corporate law is supposed to matter for development is it facilitates investment. Okay, so then the question becomes, does it? It turns out that there's not as much data on that as one would like. And then, of course, let's assume for the moment it does matter. Well, then what parts of corporate law matter? And is it the same everywhere in the US and elsewhere? I would say this is where we've seen quite a lot of discussion, although what it tells us is a little bit more, in the mist, shall we say. And then I'll talk a little bit about whether the sort of reinvigorated corporate purpose debate impacts the relationship between corporate law and economic development, and in what ways. All right, so what is the relationship between corporate law and economic development? And what's interesting, of course, is to recognize that corporate law can have multiple purposes, even within the sort of shareholder-centric model. There's investor protection, which all of us are quite familiar with, but also if one was to follow the Hansman and Crackman line of reasoning, corporate law can also be important for reducing coordination costs when you're dealing with creditors and so forth. I'm going to focus on investor protection because that's where the literature basically is. And the key argument here is relatively simple to state, which is if you're a passive investor, you're going to be reluctant to invest in a firm or a country in which you have basically very limited control, unless you have some kind of protection. That protection could be legal protection, or it could also be reputational protection, or some mix of the two. One would anticipate that this is really important for small and medium-sized enterprises because the bigger firms have other ways in which they can raise finance. They can access the debt markets. They don't face a real bankruptcy constraint, things like that. And in that respect, the sort of corporate law as investor protection is very similar to the law and economic development literature that's sort of been pioneered or closely connected to Douglas North and many others. If that is the sort of, shall we say, hypothesized relationship between corporate law and development, that is, it facilitates investor protection and investment, that raises a lot of questions. First, of course, the direction of causation. And second, does investment actually increase? And then what other issues are sort of at play? So I thought I would begin with a causation question, because that's one that has excised corporate law and finance scholars now for at least what seems like 2 decades, or if you've read a lot of the work, maybe a century. It sort of depends on how you look at it. All right, so here's a basic accounts, right? One way to sort of tease apart this question is to look at history. How did things actually develop? And what does that tell us about whether law is leading to growth or growth is leading to law or some other sort of particular dance? So on the historical development of financial markets, there's actually a decent amount of research here. So on the US, Jack Coffey has a very important paper from 2001, where he basically argues that law actually followed economic growth. And he basically suggests that the growth of the US stock markets in the late 1800s, mid 1800s, was not so much because there was great law in the US corporate governance or stock market law, but rather that investors from Europe and within the US relied mainly on the reputations of well-known intermediaries, such as JP Morgan, and social norms to sort of assure themselves that their money was not going to be completely squandered or wasted away. And in fact, he then goes on and says that these sort of reputational intermediaries and the reliance on norms might, in his view, better explain why US and UK stock markets grew faster than what we saw in France and Germany, because they were more decentralized, more responsive to changes in the markets, and so forth. I don't think we need to necessarily get into whether we buy that second part of the claim, but the first part of the claim certainly seems well borne out by whatever historical evidence we have, that actually it was not a lot of law, but more intermediaries and reputation and social norms that was critical to the growth in the US. Of course, that's the mid 1800s, and that's a long time ago, although depending on your frame of history, it may not be that long. So we figured maybe it'd be worthwhile to look at emerging markets today. And we focused on the 2 big behemoths in the room, which are China. And there's a wonderful paper by Franklin Allen and the co-authors. And the bottom line of that paper is that it's not really the law that's doing a great deal of work in China to protect investors. It's really reputation and relationships. Very similar to the account given by Jack Coffey of mid 18th century US. So, okay, well, maybe China's unusual because of the sort of communist structure and so forth. So let's look at a roiling democracy. We look then at India. And here you have Franklin Allen again with another set of co-authors and some work that others have done too, that again suggests that actually it's not so much the law as enforced, as much as reputation, trust, relationships, informal sources of financing, again suggesting that maybe it's really law following growth rather than growth following law. Of course, the counterpoint to this is the very famous LLSV set of papers and their progeny, that law is leading to greater growth. I won't go over the core argument too much because it's been subject to so much critique that I almost feel sympathy for actually the authors of LLSV, so I won't bother to do it. Basically, though, one interesting question arises from this law to growth story, which is their measure of growth is not really investment growth. It is basically whether firm value is higher. That is closely correlated with investment growth, but it's not quite the same thing. More highly valued firms may not necessarily attract tons of investment. They might, but also firms that are not performing well might attract a lot of investment too. Amazon used to throw parties for the greater losses it was receiving each year because it meant that they were selling more product. That's not quite the same thing, but they were getting a lot of investment. And of course, there is some evidence of corporate governance mattering to firm value. So if you believe firm value is correlated with greater investment, then maybe there's some evidence for law leading to growth. Of course, whenever you have this sort of chicken and egg story, you also have people who believe in omelets. So here's the omelet version, which is essentially that maybe the account is really much more mixed, much more iterative. It's not so much that growth precedes law or law precedes growth, but that trying to tear apart what happens first and what drives everything in each context is maybe a bit of a task for Hercules rather than for anybody else. Curtis Millhouse and Katrina Pister have a wonderful book on essentially what they call a rolling economic development in law, where certain law changes may lead to development, or it may be the other way around. I have a paper on the home mortgage market in India that basically makes a very similar argument, and there are actually other papers too. So that actually on a question as central as causation, there's actually quite mixed evidence. In the US, China, and India, the argument seems to suggest that growth precedes law. In some other markets, it seems like maybe law could trigger growth. And then when one does sort of more in-depth case studies, it sort of looks like there's a mixed jumble of different causative factors, one leading to the other, and maybe not necessarily in the same order in different markets. It's more that there's kind of a iterative process of development and law that sort of work together. So on one of the more fundamental questions, we're still sort of, shall we say, out to lunch in some ways. We're still trying to make a decision. Of course, from the perspective of how much does this actually benefit economic growth, we need to ask, does it actually lead to greater investment? And surprisingly, there's not a great deal of study on this. There's actually quite a bit of study that suggests you could have too much of a good thing. That is, you could give too much protection to shareholders. Remember, this is essentially a type of a bilateral market. You need investors and you need companies. If you give investors tons of rights, maybe companies will delay going public or asking for public capital much later. This is closely connected to an argument that there can be too much creditor protection, and that might potentially harm the credit markets. And so that is actually a bit of an open conceptual question. And you might think, well, this could be worthy of empirical study. And there are some papers that suggest enhancing governance improves investment. Typically, they're focused on cross-border M&A, which has a lot of very unusual attributes to it. Typically, you have foreign companies that cherry pick the best performing foreign firms to invest in or buy. That's not quite the same as encouraging investment in your country. So to take India, for example, the fact that foreign investors would like to buy Flipkart, which is a multi-billion-dollar company, isn't necessarily proof of greater investment. What you'd really want is investment to the levels a bit below that, so they become the Flipkarts of the next generation and so forth. And indeed, there's some empirical papers suggesting maybe not a lot of difference in investment. Which makes one wonder then, why push all these corporate law reforms? Because if they're not necessarily generating investment, then the sort of economic development angle at least is a bit weaker. There's also a conceptual argument here that it's possible that by increasing formal protection, you might actually hurt informal capital providers. And the logic here is basically that informal capital providers basically need to have both good firms and bad firms in their mix of, or in their portfolio of investment. If you encourage formal capital markets, it's very likely that the better firms in the set that the informal investors are financing will go to the formal markets because they can prove that they're doing well much more easily, potentially. That creates something of a market for lemons in informal capital providers. They have not as many good firms that they're able to finance because they go to the formal markets. That might lead to something of an atrophy in the informal capital markets. Now, generally, if the formal capital is increasing in a country sufficiently, it may not be such a bad thing. But we don't actually have any studies testing this, that is exploring what happens to the informal capital markets when you encourage formal capital markets. Keep in mind that in most countries that have developed, such as the US and UK and so forth, the process of capital market formation did not occur in like 2 decades, as they're trying to push in many countries. It occurred over like 150 years. That allows for transitions from informal to formal markets in a much more sort of, shall we say, parsimonious manner, rather than what we're seeing in a lot of emerging markets, where it's basically, slam the accelerator to the floor and let's see how fast we can go. That is likely to have, shall we say, destabilizing effects on the informal markets. It is interesting that if you compare to credit markets, The rise of formal markets actually does seem to undermine the informal credit markets in various ways. That may make us have a little pause when thinking about informal capital providers in a lot of emerging markets. One of the big reasons this could be a big concern is that the small and medium-sized enterprises typically don't go to the large, sort of foreign capital providers. They go to the local providers. And if there are fewer of them or they have less capital, you might have a market developing where, getting to be big enough to be, to get the attention of foreign firms is going to be hard. But once you get there, it's easy to get capital. That sort of bifurcated structure may not necessarily be such a great thing for investment growth. Or it might be. It just depends. We don't really have enough data to say, suggesting that maybe we should actually probe this research question a lot fully. And that sort of builds on that last point I'm making here. All right, well, let's say we're the optimistic sort, and we think that, yes, better corporate law, however defined, leads to more investment. Well, what makes better corporate law? What matters in corporate law? Now, Bernie Black had a wonderful paper, as Mike Klausner and others, suggesting that at least in the US, very little actually matters in corporate law. Basically entrenchment, that seems to be the big thing, right? So in the US, we have, Rob Daines with a very famous paper from 2001 on what he calls the Delaware Effect, which apparently about 4 or 5 years later seems to have disappeared. You have Sanjay Bhagat and Bernie Black with a paper on independent directors where they find they don't seem to matter much, at least in the US. And then you have what seemed like a gazillion papers on specific features of corporate law, anti-takeover laws, extension of mandatory disclosure laws, the size of the board, audit committee, et cetera, et cetera, et cetera. There are papers on both sides here. It seems that some say, yes, they matter. Some say they don't really matter. And then you have papers that say, well, let's not look at individual parts of governance. Governance is a system. So let's look at, an index of the system. Corporate governance indices. You have the famous G index, the E index, and then you have critiques of the various indices. They're sort of all over the place. Mike Klausner has a wonderful paper that basically says, look, the only thing that matters in the US is entrenchment. The only thing that doesn't matter in most other countries is entrenchment. So what are we learning from these CG indices? We're not really sure. And do you really need a lot of factors? Is just a measure of entrenchment all you really need? One can debate that, but the point being that actually what matters in governance, even in the US, which is by far the most studied market, is not really all that clear. In the rest of the world, well, it turns out that the problem is different. You don't have as many diffusely held firms, so you're not really worried about management running away with a kitty. What you're worried about is a controller running away with a kitty. And there, entrenchment isn't really an issue. They are entrenched. There's no way to deal with that. What you're worried about is, can you get a sense as to what risk you're taking by investing in this controlled firm? For that, there's much more focus on disclosure and shareholder rights. There is evidence that corporate governance does matter, but that could simply be because you're starting from a different base, right? That the kind of reforms you're putting in are reforms that build on essentially relatively weak structures. And you can try to maybe address this by having country-specific corporate governance indices, or even country-specific factors that you think matter the most. In the US, entrenchment; in other countries, maybe disclosure and shareholder rights. As a result, even if we're the optimist and believe that corporate law matters and that it encourages investment, we don't really know what parts of it do. So that if you're making law reform suggestions, if someone asks you, well, okay, what should we adopt from the US? Your response might be, try everything. We don't really know. And we know some things don't really work, but not a ton. And indeed, the problem is, adopting anything from the US runs into the core problem that the ownership structures are different. Are you really addressing the same problem? Not really clear you are. To make matters more fun, I thought I would add in the discussion of, well, maybe the purpose isn't only just shareholder wealth maximization, right? Much of the analysis has moved on the basis of shareholder wealth maximization as being the norm. Well, it turns out over the last 5 to 10 years that a lot of people aren't really sure that is or should be the norm. So how does that debate actually influence how we think about these issues? So of course, you have the standard dichotomy here: shareholder primacy versus stakeholder theories. Shareholder primacy is investor protection. Stakeholder theory is something more than investor protection. I'll just phrase that way. By definition, stakeholder theories should have differential effects on investment because they're focused on things besides investment. That seems to, almost be a tautology. But in practice, it's not really clear they're all that different. Shareholder primacy in the US is exceedingly easy to turn into stakeholderism if you wish, right? I mean, the business judgment rule allows boards to basically do whatever they want as long as they're unconflicted, informed, and acting in good faith. So if they in good faith believe that donating, $100 million to the University of Michigan Law School to start a center on comparative corporate law, something I would encourage them to do, is in the best interest of shareholders, and they've gotten an independent, informed view on that, there's really not much Delaware corporate law is going to do about that. They'll be pretty much fine with it. That basically suggests that the big difference may really be more in terms of, can the board openly say what it's really doing? And secondly, who has the ability to enforce fiduciary duties? One of the fascinating things about countries that have stakeholder theory is that they rarely allow for stakeholders to actually enforce the duties. They're often admonitions to the board. And in some countries with dual tier structures, they may allow labor to have some say. But beyond that, if one is thinking that stakeholder driven countries allow people representing the environment to sue or have a voice in the board, that's not really how those systems work. Having said that, let's for the moment assume that the stakeholder theory driven jurisdictions are actually different in some material way. Would we then expect to see differential investment? I anticipate we would. It's not entirely clear to me whether it's more or less, though, right? One of the reasons for that is if you look at studies on the rest of the world that typically has more stakeholder-oriented jurisprudence, at least in theory, it doesn't appear that their ability to raise investable capital is terribly hurt by that. I mean, if you looked at Germany, it doesn't really look like their dual tier structure is leading them to have great difficulty in raising money. Berlin is one of the hottest places to do venture cap. I still find that amusing, but it is. So is Bangor. They don't have a lot in common except they begin with the letter B. So one wonders a little bit as to how much of this is really driving things. Another thing, though, is that stakeholderism may actually have serious political benefits for countries that are in that sort of emerging or transition phase. Market-oriented reforms are not always popular, even in market economies, it turns out, right? In that context, if you really want to be able to do a large amount of market-oriented liberalism, let's say, or even mixed market liberalism, you're going to need political support for your reforms. Saying that everything is being done to maximize shareholder wealth may not really generate those kinds of political support. And as a result, you see countries that are in that emerging phase, a transitional phase, often pushing for stakeholder theories. A great example is India, that mandates companies above a certain threshold spend 2% of their profits on CSR, corporate social responsibility. That was started in 2013 on a comply or explain basis. Then it became mandatory. Then it had criminal penalties on it for directors. Wow, you could go to jail for not engaging in philanthropy. What about that? They have sort of abandoned that recently, I think because someone pointed out that that does seem slightly harsh. But nonetheless, the logic behind it explicitly was that this requirement is necessary because otherwise other market-based reforms might not get the kind of political support they need. I think one has to be actually quite sensitive to that in the context of emerging markets, and even more generally, that the political optics of what you're trying to do matter to the kind of support you're going to get and the coalition you can build. So that in some ways, it's plausible that a more stakeholder-oriented approach, or maybe at least the verbiage of it, whether or not the reality is open to debate, may actually be helpful in some contexts for facilitating investment, and in others may not. That too is sort of one thing that one might want to get empirical evidence on. And to the extent there are empirical tests, they're all over the place. And that sort of makes it hard because you're always going to run into the problem of the counterfactual. What would investment have been in France if they weren't more stakeholder oriented? I don't know. That's, I do empirical work. I know counterfactuals are hard. I mean, I would have to create another France and have it run on a shareholder primacy system, controlling for everything else. Good luck with that. That's just exceedingly difficult. I mean, it'd be ideal if France, was willing to I'm just using France as an example, of course. It'd be nice if France was willing to say that, this part of Paris will be subject to shareholder primacy and the neighborhood next to it will be subject to stakeholderism, and let's see what happens. I somehow don't anticipate them doing that anytime soon. Although emerging markets do that. They create special economic zones, which do something like that. But it's not just the corporate law that they switch. They switch labor law, environmental law, so it becomes hard to really test. Of course, that is looking still at investment. You could, in theory, say, what if there were other things that were influenced by corporate law, coordination cost, innovation, etc.? Then, boy, you've really opened the Pandora's box. And I think it becomes really difficult to make strong claims about things because what affects one may affect the other in a different way. My point is not necessarily to be defeatist. I tend to be more of an optimist, than that, although, hence the halo. But the gist of it is that one is making arguments about how corporate law facilitates investment. There are actually a lot of embedded assumptions in that. Some you might be able to actually overcome or explain as you're doing your comparative or other work. Others, I think one has to be just a little bit more, shall we say, cautious about in making assessments in terms of whether or not they're really going to lead to where you think it's going to lead. Okay, I know I must be running very close to being out of time, so Yaron will be happy to see the conclusion slide. I love conclusion slides because I usually don't repeat what's on them, because if I have, that means I haven't been very clear at the beginning. I will only say this, that I think the issue of corporate law and economic development is not nearly as simple as people think it is. And that in terms of making policy prescriptions, I think that requires a great deal more contextualization that is typically given to how people think about, what sorts of reforms do we implement in another country. The typical approach is cut, paste OECD and see what happens. That would be the equivalent to saying, let's make a vegetable biryani by adding in, wild rice. And my response would be, let's not, and to sort of see how it goes. Not that I dislike wild rice, it's just I like biryani way too much to sacrifice it on the altar of such a claim. Anyway, with that, I'll end, and I'll be delighted for any comments or suggestions you might have.
Thanks, Vic. I think Virginia had a comment in the chat.
Okay.
I guess I'll just we have just a few minutes, but I'll play contrarian for a second and push you on the premise of your very thorough kind of review and do we need even to kind of measure governance through the prism of financial outcomes or firm value? Is that in itself maybe like a fool's errand, right? And you can have two lines. There's the pragmatic one, which is just empirically it's almost impossible to be able to do it, and that's why we have this, it's served a lot of academics to be able to write a lot of stuff that published well because it's interesting, but for every empirical paper that comes, you're going to have you can bet that there's going to be another one that will basically refute the results.
Most economists have two hands. Yes.
And then you can have also kind of more of an ideological kind of perspective that this is not the right measure to view corporate governance, that what we are trying to protect here is not necessarily kind of specifically firm value, it goes a little bit to your hybrid theory of it doesn't really matter too much. It's the complementary forces. I view kind of reputational and kind of informal channels as kind of substitutional / complementary channels to corporate governance. So that's kind of my question to you.
Fair point. And it's the reason I framed it that way is basically because in the literature on comparative corporate governance, and certainly in the policy reform areas where they're suggesting what policies other countries should adopt, the usual sell or the pitch is if you have better corporate law, that will lead to investment flowing into the country and to economic growth. I think the judge is a little bit out on that. The jury's out on that still. I don't think that it hurts necessarily, unless, of course, it begins to squelch out informal financing. And what I typically find is very little attention being paid to how things are being financed now in a particular market, right? Because the informational advantages people have that are local are severe, right? And if what you're doing is undermining that market without being able to imbibe that information in some way, or at least translate it into a format you can use in the formal sector, you're not going to actually benefit that market much with investable capital. But if the question is instead, what is good corporate law, right? Regardless of whether it does anything for investment, then I absolutely agree that, you know, the standard measures of firm value are much better in that regard. The only trouble is that even there's actually quite a lot of debate about what works, hence all the indices and hence all the studies, right? But certainly in this area, when you're talking about does this contribute to growth, which is a sales pitch, it's not really clear that just the photocopy, cut and paste works. I do think if you contextualize it, it will benefit a lot the market. It's just often they don't do that, and that's a bit unfortunate. Or they don't do it initially. They put in the photocopied version and then they kind of tweak it over the next, you know, 1 or 2 decades.
Yeah, fair enough. Any other comments from the panelists? Yes, Afra.
I was just going to echo Virginia's point, Vic, that she made about the political messaging regarding stakeholders. And I think you're really onto something. And I think the political messaging is in some ways like extremely complex, because one of the things like I've noticed with and I've written about in like a recent chapter on India CSR reforms, is I think how it's not just a messaging to try and get a political buy-in for the changes in business regulation, but it's also to get relieve political pressure from the state.
Yeah.
So that, you know, in these jurisdictions where perhaps the state isn't able to achieve what it needs to achieve or what people expect it to achieve from a development standpoint, placing the pressure on companies to do some of this actually relieves some of that pressure as well.
Yes, no, I think that's absolutely right. And I agree with I saw Virginia's very helpful comment. So, you know, it's interesting in the Indian context, when they came out with the CSR reform, where they said companies have to spend 2%. But one of the funniest things was the reaction amongst the NGO community. You know, I got to know some of them. I don't necessarily do a lot of work in that space, but I just happen to know them. And so I talked to them and I said, what do you think about this? They said, we are delighted. I'm like, you're delighted? I mean, doesn't this seem like the government is abdicating their responsibility? They're like, what makes you think they were doing it before? Right? Basically. And I'm like, okay, fair enough. And I said, well, why do you think the corporates would be better at it? They said they're used to doing deliverables. I said, I see. So this is really an argument about private provision of public goods, right? And I asked them, I said, why don't, what's wrong with a model where the government, instead of asking companies to spend 2% of their profits on CSR, just taxes them 2% and spends the money itself? And they said, the problem is the government spending. I said, what does that mean? They said, they're terrible. They don't know what the hell they're doing. And I said, well, come on, it can't be they don't know what they're doing. They said, yeah, there's so much seepage. There's so much lack of interest. They said the company will want to make it look good because they want to advertise success, right? So in some sort of more conceptual work, I remember talking to them and saying, do you think that the private parties would be good for all public goods? And they said, no, not for anything that has like a longer term payoff, but for anything that has a payoff in the 1 to 3 year time frame, we think they'd be better than the government. That's interesting, right? I mean, not on a corporate side per se, but it's just interesting when you're thinking about how do you provide these goods in this sort of mixed public-private structure. It becomes an institutional account story. The political story, I think, is very interesting. Also, just, in the US, one may not think, oh, you need to do big reforms, but maybe they're trying to avoid certain kinds of regulation too, right? The optics matter a lot in how one thinks about this. Mark Rowe's written some really interesting stuff on how politics interacts and how backlashes work in the corporate side. But more generally, I think that, if you're doing reform, you can't have a 10-year to how it's being perceived. That's just not smart.
Well, with that, I think we're out of time. I would like to thank all of you for a really fascinating panel. Really kind of everything, not surprisingly based on the book, everything supplemented and enrich each other. So I had the pleasure of moderating it. I know people in the crowd seem to be enjoying it too. And really, I wish we could have hosted you in person. You have an open invitation to come to Madison whenever. But in the meantime, it's been a pleasure to have you over. And thank you for fascinating presentations.
Thank you, Ron.
Thank you.
Thank you, everyone.
Bye.
Bye, everybody.
Bye. Hope to see you all soon.